Ladies and gentlemen, hit subscribe to this channel right now. Huge victory for Trump on the horizon. Tomorrow, oral arguments in the Supreme Court for immunity will take place. He has already received a huge victory in terms of presidential immunity. The court essentially has already given, has already given, based on the arguments you will hear right now. Huge victory in terms of partial presidential immunity. You'll hear arguments in the January case, and that will foreshadow what's going to take place tomorrow and the rest of this week and next week. The Supreme Court is going to give Trump partial immunity. That does not mean complete immunity. They'll have to rewrite the indictments. That will take a sledgehammer to a special counsel case that's already absurd. But the special counsel will be dissolved when Trump becomes president November 1st. He'll just completely dissolve the special counsel. But listen to this. This is one of the reasons right here, this interaction with Neil Gorsuch, Justice Gorsuch, and Justice Alito, and Justice Kavanaugh. This is an interaction between the DOJ lawyer the other day and the justices on the Supreme Court pertaining to the double standard in terms of you have a Democrat congressman in New York that tries to obstruct an official proceeding by committing a crime. Nothing is done there, but they're throwing the book and they're trying to combine two arcane legal statutes against defendants who did commit crimes in January but don't deserve 20 plus years. So hit subscribe to this channel. This is absolutely huge. The Supreme Court has already showed the world they're not going to abide by or allow a very vindictive and petulant analysis or viewpoint or interpretation of legal statutes simply to go after Trump. He was a president with the ability and power and authority to perform a speech. And because of that, they're going to say, yeah, he can perform a speech, but perhaps he can't do other things. Or he might not be able to do other things. It'll probably be 6-3 or 5-4. You might even get a liberal justice siding. But listen to this right now, and you'll understand where I'm coming from.
Between Judge Katsas on the D.C. Circuit and Judge Nichols on the District Court.
Competing interpretations of what?
So, and it relates to exactly the question you asked me, which is that Judge Nichols thought that C1 should limit C2, and he looked at it and said, well, the relevant thing about C1 is it deals with records, documents, and other objects. And so that means C2 should be limited only.
Now, this is very important, ladies and gentlemen. This will show that Trump is going to get a huge presidential immunity victory, okay? Because every single interaction, and you saw this with the 9-0 Supreme Court decision backing Trump and overturning the Colorado ban that I said would take place. I told everyone long before media admitted defeat and Democrats just, said, oh, well, we lost 9-0. We can't say that he is a, big menace to democracy. We actually lost in a unanimous Supreme Court decision trying to ban him in every state. So the ballot case was overturned. Now listen to Neil Gorsuch, Justice Gorsuch, and Justice Alito. Justice Gorsuch, you will hear in a second, and the DOJ lawyer is very much like the Colorado lawyer, trying to educate, being very pedantic. The justices don't want that. They know that there's so much politics infused in these trials, in these indictments, and they are the only institution in the United States of America that isn't completely influenced by a public relations monstrosity called U.S. media, the Democratic Party, Hollywood. But hit subscribe and listen to this right now. This is very, very important, and be here tomorrow. I'll have 2 live streams tomorrow.
Only to other acts that impair physical evidence. Meanwhile, Judge Katsas looked at the specific intent requirement in C1 to take action that impairs the availability or use of the evidence, and he divined a broader gloss to put on C2 and said it should be other impairment of all other evidence.
Well, they're just applying the same doctrine to different aspects of it, and I think you do that as well. What are the common elements? Alters, destroy, and mutilates a record or a document. You have the first few, what you're doing and what you're doing it to. And you apply both of those in, as it said in Boisonette, controlling and defining the term that follows, so that it should involve something that's capable of alteration, destruction, and mutilation, with respect to a record or a document. That's how
I actually don't even understand.
When you apply that doctrine, again, as we did on Friday, it responds to some of the concerns that have been raised about how broad C2 is. You can't just tack it on and say, look at it as if it's standing alone, because it's not.
So let me respond to that in two ways. I do want to have a chance to address any concerns about breadth, but the more fundamental point, I think, is that I don't even understand petitioner to be suggesting that you can mix and match the verbs and the nouns from C1 and C2 in this way. Judge Nichols had a more limited view that C2 exclusively focuses on physical objects. It wouldn't apply to things like testimony because of the limitation that he gleaned from C1. Judge Katsas, I think, may be in line with your question, would interpret it more broadly. And the basic point as a textual matter is that there is nothing in the text of C2 itself to disclose what the relevant similarity from C1 ought to be. Instead, we think the relevant similarity is obstruction of an official proceeding, because that's the language Congress chose.
General, if that's the case, what work does authorize do on your theory? Because I think I might, as I'm hearing you,
the all
This is Justice Gorsuch. This is exactly why they're going to give Trump presidential immunity. Listen to the interaction and the discussion where, just like with the Colorado arguments, the lawyer is not able, the DOJ or the Democratic Party or the liberal Democratic Party leaning, government leaning lawyer is not able to convince the conservatives on the Supreme Court. Check this out.
And the basic point as a textual matter is that there is nothing in the text of C2 itself to disclose what the relevant similarity from C1 ought to be. Instead, we think the relevant similarity is obstruction of an official proceeding, because that's the language Congress chose.
General, if that's the case, what work does authorize do on your theory? Because I think I might, as I'm hearing you, think that whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so stands alone. And the otherwise, I'm not hearing what work it does. Can you explain to me what work it does on your view?
Yes. So the work that otherwise does is to set up the relationship between C1 and C2 and make clear.
They're contesting the lawyers' interpretation of legal statutes, which is what they did before a unanimous ruling. That is why when the court does this, when the Supreme Court does this tomorrow and the next day and next week during the presidential immunity arguments, okay, the entire special counsel will be dissolved after Trump wins, but they'll have to rewrite and redo the indictments. Because all of these cases, whether it's imprisoning the January protesters or demonstrators or people who committed violence, they do so from a political viewpoint, from political sensibilities. They indict based on political retribution. So there were billions in property damage. You had law students throw incendiaries at police vehicles. Nobody was given 20 years. Then you have the Carlson footage where people were let into the building. The DOJ doesn't want to see that. And so these justices are asking, well, wait a second, you want two legal statutes to imprison people using the maximum sentence when these legal statutes don't really say what you think they say. And they'll do the same thing with presidential immunity. Why isn't Trump immune from a speech? He didn't try to interfere with the proceeding with his speech. He used the word peaceful. The speech is the basis for the indictment. They want to imprison him based on a speech, not breaking into a bank, not calling to end the life of an opponent, which even his own lawyer stated, yes, he could be indicted, but they said he should be impeached first. That's a lie when you hear that Trump was actually trying to say that he shouldn't be indicted. That's not true. It was a qualified, well, yes, he could be in prison for that, but he should be impeached and convicted in the Senate. But anyway, the point is, of course he can't do that, but there wasn't an actual criminal act. What they did is they tried to use speeches, speaking to political allies as a crime. They tried to say that these acts that are legal were actually done so with criminal intent and resulted in criminal acts. But they're not going to allow that to take place based on these interactions. Now let's continue to listen.
That C2 does not cover the conduct that's encompassed by C1. Now, I acknowledge that there would have been...
Beyond saying, okay, C1 does some things, and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view?
Yes, but there was a good reason for Congress to do it this way.
I
traces to the statutory history.
I understand
and
that.
I would just say that...
If I might. So what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
The lawyer knows that Gorsuch is referring to Democrats who caused or committed criminal acts. For example, the New York congressman. Gorsuch is asking, are they too going to get 20 years? And the lawyer, in a verbose, pedantic manner, says, well, essentially, this isn't exactly what she's saying, but from a political perspective, she's saying, well, there's rules for Democrats and there's rules for Republicans. Because, a left-leaning demonstrator might not have the intent to commit chaos and mayhem and criminal acts because, so you'd have to prove a whole bunch of things, which, of course, you proved in January, even though video footage shows that has resulted in people being acquitted already. People were let into the building, in many cases by law enforcement, and still they're charged and given the maximum or, egregious sentences. While you had billions in property damage and left-leaning organizations bailing out people who committed crimes, who in some cases then committed more crimes. That summer, in Trump's last year in office, Democrats and the Dobbs decision, you had left-leaning protesters committing crimes all the time, and Democrats never condemned. And so you never have the Republicans that are opposed to Trump condemn the violence and vitriol and mayhem and chaos and criminal behavior of those on the left who demonstrate because, well, then they'll get negative media coverage. You don't see Romney or Kinzinger or Cheney shedding any tears after the Dobbs decision, or when Chuck Schumer when his words led to somebody trying to take the life of Justice Kavanaugh, or the billions upon billions in property damage throughout the country. It was always fiery but mostly peaceful, according to CNN. Well, but that's when it comes to a righteous demonstrator, someone who votes for Democrats, they're good people. When it comes to a Trumper, a mangy Trumper, well, then you throw the book at him.
There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal outburst.
Okay,
We don't think it falls within the
So Gorsuch is going to push back at minimal billions in property damage, taking over state courthouses, campuses throughout this country where, here's a newsflash for people like, wonderful, idealistic, wonderful university people. You are only allowed a certain time to protest and demonstrate. And you also have to, in many cases, get permits. And when the police say, or law enforcement say, disperse, you must go. So your First Amendment right to demonstrate, and this is why you had thousands of people, I think it was like 14,000 arrests, something like that summer. You had 14,000 arrests. You had hundreds and hundreds of law enforcement officials injured. And the only law enforcement official in that summer, in Trump's last year, the only law enforcement officials they cared about were those injured one day in January. God bless those people, and God bless all the people who were injured trying to protect Americans throughout the summer. How do you differentiate, if you are a morally superior liberal Democrat, between billions and billions in property damage, curfews every night in every major city, businesses being boarded up, windows being boarded up, and in many cases, in major businesses, we side with you. Please don't torture, destroy our business. I mean, Tim Pool talks about this a lot. He's fantastic. He's right about a lot of this. Anyone with a functioning brain cell can see there are two standards where media and the federal government at this point will look at and say, well, if it's a left-leaning demonstration, they can push the envelope and go beyond the envelope. If it has anything to do with Trump at all, throw the book at them and listen to the Justice Gorsuch.
My outbursts require the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we have to show that, yes, they were aiming at the proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent.
And where was the corrupt intent and the knowledge of obstruction when people were let into the building, according to video footage that the January committee withheld, exculpatory evidence? Where was the intent and all of these other factors that have to be addressed? Because when it comes to a defense of politics or the First Amendment from the Democratic Party side, which is what Gorsuch is alluding to, you see the DOJ lawyer, there's many hurdles that we have to go. Oh, really? And when people were actually let into the building that day, and this segment is not about the January cases. This segment is about how the justices don't buy the special counsel or the Colorado Supreme Court arguments, and they're not going to buy the special counsel arguments on immunity. You're not going to be able to say that Trump committed a crime because of his speech. That's game over. It doesn't matter if they say, well, the speech, if they say, well, Trump can be convicted. If they say, but his speech, or but parts of his speech, or but he's able to speak to his political allies, whatever small amount of immunity they give Trump will be an overwhelming victory. That's why you're seeing articles in liberal publications saying, well, they're probably going to be in Trump's pocket, the Supreme Court, because they're already bracing for defeat. And this is a huge, huge upcoming victory for Trump. I told you it would be a unanimous Supreme Court decision overturning the Colorado ban. And I'm telling you right now, he's going to get some immunity a sliver, at least a tiny, percentage of what he's accused of is immune from prosecution, that is enough to completely implode the case against him. So listen to this.
In acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent. So mostly peaceful protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered? Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yes, if they intend to obstruct and were able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes, that's a 1512c2.
Where was the evidence of intent for Trump to obstruct? He said nothing regarding obstruction. He said the word peaceful. He said go peacefully and patriotically. He never told anyone to commit a crime. He wasn't even there. The Federal Bureau of Investigation found no concerted effort to engage in any kind of rebellion or obstruction with Trump. So why do they want to imprison a former president because of a speech that they say the speech resulted in criminal acts, but there's zero correlation between what Trump said. Absolutely zero correlation between what Trump said and the criminal behavior. He never told anyone. Number one, he never told anyone to commit a crime. Number two, he literally told peaceful people to be peaceful. Number three, it would never have helped him. Even if you think that Trump, in a diabolical plot, tried to obstruct proceedings, do you think that he was just going to obstruct everything and then remain in the Oval Office? The guy left. It's still not enough. They were saying he's never going to leave. Then he left, and then they're like, oh, wait, we have to imprison him because he didn't leave in the manner we wanted him to leave. And they care so much about that one day. It's like, if you don't like mayhem and chaos, then why do you turn a blind eye to mayhem and chaos an entire summer? Or what's taking place in universities? Or like whenever left-leaning demonstrators, CNN and others, oh, it's mostly peaceful, it's fiery. There's a CNN journalist in front of a building in flames. It's mostly peaceful, very peaceful. But with Trump, it was literally mostly peaceful according to that paradigm of thought, but it's Trump. You throw the book. Millions of years of prison for Trump.
Offense.
What does corruptly add, in your view?
When I was accepted to SGU,
adds the requirement that the defendant's conduct be wrongful and committed with consciousness of wrongdoing. And this traces to the court's decision in Arthur Anderson, where the court said this is a term with deep historical roots, with a settled meaning, and that it connotes not just knowledge of your actions, which is, the intent to obstruct in this case, but further requires that it be done corruptly. And just to give you a more concrete example of how this has played out in the January 6 prosecutions, I'd point to the jury instruction in the Robertson case, which we refer to and quote in part on page 44 of our brief. There, the jury was instructed that in order to show the defendant acted corruptly, the jury had to conclude that he had an unlawful purpose or used unlawful means or both, and that he had consciousness of wrongdoing. So I think that is an encapsulation of what the jury is asked to decide on top of the mere intent to obstruct.
General, let me give you a specific example, which picks up but provides a little bit more.
They did not buy the Colorado lawyers' argument defending the Supreme Court banning Trump. That's why it was a 9-0 decision. I'm not exactly sure how they'll rule here. They'll probably rule against the DOJ in some capacity or special counsel regarding the sentencing disparities between, the more conservative demonstrators that committed crimes and the apparent, the past couple of years, left-leaning or liberal demonstrators that committed crimes but didn't get sentenced 20 years or so. But I don't know. I can't really tell you exactly what will take place. I think they'll probably side against the special counsel. or the DOJ going after the January defendants in some capacity, but they're not buying. You can see they're not buying the argument. With Trump, whether it's the Colorado ballot decision or whether it's these statutes they're trying to utilize in concert with one another to imprison people for long periods of time while ignoring the same types of crimes with left-leaning protesters. They're not buying it because the Supreme Court, number one, is more conservative than it is liberal. Number two, even the liberal justices sided with Trump on the Colorado ban. The entire argument was Trump committed a rebellion. Nobody on the Supreme Court believed that he committed a rebellion. He's never been charged even with that. He's never been indicted with that. Yet the morally superior among us believe he did. The people who believe complete nonsense, hoaxes, the most conspiratorial theories are those who wake up in the morning, read the New York Times, Washington Post, go to bed at night listening to Kimmel and Colbert, and that's called mainstream. That's why they have people on the hush money case. They're trying to vet. Oh, well, where do you get your news? Oh, the New York Times and CNN. And that's supposed to be apolitical? Are you kidding me? What about Fox News? You can't get a Fox News in there. So, he'll very likely get convicted, although you could possibly get one person with enough courage. But see, again, all of these cases will be overturned either on appeal or what's going to take place with the Supreme Court. They're not going to be able. Trump did not commit a crime. Clinton did with private servers. Categorical. James Comey, the Honorable James Comey said she did. Biden did commit crimes. Special Counsel Hearst stated he did. But he stated that no prosecutor, just like the Honorable James Comey, would prosecute. No reasonable court would indict and prosecute and imprison. That's the double standard. When you have law enforcement or government officials saying, well, it's not reasonable to imprison Biden or Clinton, but it's very reasonable to imprison Trump, that's the problem. Hit subscribe if you're new to this channel.
More detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout.
Connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes. Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of
plain
as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is.
When you get a Supreme Court justice, that is giving the definition of a word using Webster's dictionary, that's a problem for the special counsel. That's a problem going forward. Check this out again.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of
plain
as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is to retard in progress or action.
Why don't you?
Obstruction requires the causing of delay.
And if this court...
Again, why wouldn't that fall within... Now, you say, well, we're not going to prosecute that. And indeed, for all the protests that have occurred in this court, the Justice Department has not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But why isn't that a violation of 1512C2?
We read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well, that's not a corrupt intent. It's wrongful. Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say that
when confronted, and George Rivera Jr., thank you to the members of this channel. Thank you to my super chat. Thank you so much. George, thank you. When confronted with the reality that, hey, there's a double standard, and people have tried to impede or interfere with official proceedings in the past. They didn't get 20 years. They didn't get 20 years. And when you get a Supreme Court justice utilizing the definition of a word and saying that's not what this word means, the DOJ lawyer is not winning the case. The reason I'm showing you this is because this is a precursor. This happened a couple days ago. This is a precursor to the immunity oral arguments. Tomorrow we will have a live stream. I should have a live stream about 5 p.m. Eastern or 6 p.m. Eastern, and then another one 10 p.m. Eastern. But they're not buying it. The Supreme Court is 6-3 conservative, and these are not like issues of congressional laws passed. These are issues where the Constitution, you're interpreting the Constitution. So when you're interpreting the Constitution and you're trying to say that Trump should be banned in every state because we believe he committed a rebellion, the Supreme Court ain't going to buy that. If you say Trump should be imprisoned because he tried to impede an official proceeding, well, how did he do that? Well, his speech was mean. His speech stated that he didn't accept results. Oh, by the way, the hush money trial is all about Trump, apparently Trump cheating, and Democrats still haven't accepted 2016. They're literally trying to imprison him in New York, based on a hush money, an NDA that the FEC did not find to be a crime. So where they get the federal crime, nobody knows. But again, a potential or likely or inevitable or whatever conviction will be overturned on appeal. Just like the presidential immunity victory will force the special counsel to rewrite the indictment, or it'll force the case to be held way after November 5th. Democrats wanted all of these cases before November 5th to interfere. And if the tables were turned and Trump did this, they would say he was a tyrant and a despot, an authoritarian and totalitarian. And meanwhile, they're the ones doing this to Trump, and it's just the rule of law. Nobody's above the law except, Biden and Democrats and left-leaning demonstrators who commit billions in damage. But nobody's above the law. Nobody's above the law.
That they weren't conscious of the fact that they weren't allowed to make that kind of brief protest in the court. And I think it's in a fundamentally different posture than if they had stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and done so with clear evidence of intent to obstruct.
Absolutely. What happened on January 6th was very, very serious, and I'm not equating this with that. But we need to find out what are the outer reaches of this statute under your interpretation. Let me give you another example. Yesterday, protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco. What if something similar to that happened all around the Capitol, so that all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there? Would that be a violation of this provision?
It sounds to me like that wouldn't satisfy the proceeding element nor the nexus requirement.
Why would it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
Well, if we had clear evidence that the purpose of the protesters who had set.
Again, Alito and others are not buying it. They're not buying the argument. They won't buy the presidential immunity argument. The indictments, if you read them, are so ambiguous and broad. They try to accuse Trump of everything under the sun. The problem is, if Trump is in prison for things he didn't do, the Constitution is then rewritten to appease liberal sensibilities or Democratic Party sensibilities in 2024. A conservative Supreme Court isn't going to do that. Number one, because it's unconstitutional to do what they've done to Trump. We know this with the 9-0 Supreme Court victory Trump had, overturning the Colorado ban. But Trump did not rob a bank or break into the Watergate building. He performed a speech. That a speech is protected under within the Constitution. A speech. You're not going to hurt anyone with a speech, especially when you literally do not tell anyone to do anything. If Trump said, I want you to go and commit the most amazing crimes, then it would be different. But he didn't say that. He didn't say. It took them 4 years to get to this point when he could have been indicted that month. The Federal Bureau of Investigation could have said, yeah, that speech directly led to... and by the way, there's no defendant stating that Trump's speech made them do anything. That's not even a defense. So then how are you going to imprison the man if even the defendants aren't saying, yeah, Trump made me do it?
Set up the blockage somewhere, some distance away from the court was because they had a specific proceeding in mind. Maybe you have the proceeding, but still the court has required a nexus, and that's been the requirement in cases like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work because you have to show that the natural and probable effect of the action is to obstruct. There has to be a relationship in time, causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute 7212, that use this exact same formulation that the court has characterized as an omnibus clause and never suggested could be subject to an evidence gloss. So I don't think that to the extent you have concerns about those hypotheticals, your question about what would happen in this courtroom could be covered by 1503. And interpreting this statute narrowly isn't going to cure that issue.
Let me give you one.
Most people have.
Go ahead. One more example. An attorney is sanctioned under Rule 11 of the Federal Rules of Civil Procedure by filing pleadings, written motions, or other papers for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. And in a particular case, the judge imposes Rule 11 sanctions and says, this caused a lot of trouble. I can tell you it caused at least 5 work days for me personally, all of this unnecessary paper. And it delayed the progress of this litigation. So I'm imposing Rule 11 sanctions. Why doesn't that fall within your interpretation of this provision?
Congress created a specific safe harbor in 1515C. It's reprinted at page 17A to the appendix of our brief that specifies that advocacy or legal representation that is conducted as part of a proceeding shouldn't be understood as obstruction. So I think Congress was itself trying to draw some lines around participation in a proceeding on the one hand versus external forces that obstruct the proceeding on the other.
But it falls within the language, doesn't it?
What kind of evidence do you typically present in?
So you can see from this Vox article, this is from the other day, they're already preparing for a loss, okay? If you read the actual indictment, it's a very broad indictment against Trump, okay? The Supreme Court is going to save Trump because it's not politicized. They're looking at the rule of law. Okay, and if you say, well, you're saying that because you like Trump, it's like, well, the liberal justices sided with Trump. The 3 liberal justices did not side with the Colorado Supreme Court. And it's like you have a situation, ladies and gentlemen, where when they try to imprison Trump. Okay, they try to imprison Trump using legal statutes that they would never utilize against Democrats. For example, Chuck Schumer literally stated very threatening things to the justices. They're not imprisoning Chuck Schumer. They're going after Trump for a speech using statutes they could imprison Democrats with. And so the Supreme Court is going to look at that and say, if we allow this, then every single future president will then have to deal with these problems. Now listen to Trump and his lawyer really quickly. This is exactly a little bit, when you listen to Trump's legal team, their argument is very similar to the arguments of the justices, the Supreme Court justices, debating the Colorado lawyer and the DOJ lawyer you just heard.
Good afternoon. I'd like to make some comments on behalf of President Trump. First of all, this was a momentous day. This is the first time in our nation's history that a sitting president has decided to prosecute his major opponent who's leading in all the polls in the country. The issues that the court had to deal with today were momentous. Whether or not a president of the United States could be prosecuted for carrying out his responsibilities, doing his job as president. We can't have a country where every 4 years there's a cycle of political recrimination, where one administration attacks a prior administration, when in fact that candidate is leading in the polls and will be the next president of the United States. As our legal team, as our appellate team made clear, that would be a disaster for our country. That would be a direct attack on democracy, and that cannot happen.
If you can't donate today, don't even think.
Very significant today, and I'm sure you all caught it, is the special counsel conceded that if it was President Obama who was being prosecuted for a drone strike, then they'd have to consider immunity. But when it's not...
All of these arguments are predicated upon rules for thee, but not for me. Democrats know very well, the special counsel, the DOJ lawyers, the Colorado lawyers, they know very well that whether it's demonstrators or politicians, people associated with the Democratic Party, when they do the same things or similar things as Trump voters or people who support Trump, they get treated differently. But the Supreme Court is not politicized in that manner. That's why you're going to get, oh my God, the Supreme Court's in Trump's pocket. But they'll never say a New York court is in the Democratic Party's pocket. And so they do the same thing they accuse Trump of doing. When God bless him, Trump's, in many cases rightfully, disagrees with a certain court or says, hey, this court is biased, the Democrats say, oh my God, he's going after his political rivals. He doesn't respect the rule of law. Then Democrats go after the judges that are fair to Trump, or the Supreme Court that's fair to Trump. Like, oh my God, the judge in Florida, oh, the Supreme Court, oh my God. And then the Supreme Court won't save us from Trump. You're going to save, you know what? You're not going to be saved from a better economy and a better foreign policy, God willing, very soon. The only thing Trump did wrong was defeat Democrats. Whenever you hear a morally superior liberal Democrat say Trump is harmful, he's, oh my God, a danger to this country, what they mean is there goes their political power, and they crave that political influence. So it's like their lifeblood. It's so important to them. It's their identity. It's who they are. And a lot of Democrats now are finding out their party is completely irrational, borderline insane. But anyway, let's continue.
When it's President Trump, then they're taking the position that there's no immunity for presidential acts that were required when a president is carrying out his job responsibilities. If we adopt what the special counsel wants, if we adopt what President Biden wants, then we open the Pandora's box to political prosecution after political prosecution after political prosecution. In fact, Joe Biden could be prosecuted for trying to stop this man from becoming the next president of the United States. We don't need political prosecutions, we need political process. I'd like to introduce President Trump.
Well, I want to thank you all, and we had a very momentous day in terms of what was learned and what they've conceded. They conceded two major points that were they were right in doing it. I don't think they had much of a choice, but they're very, very big, very powerful points. And I think we're doing very well. I think it's very unfair when a political opponent, is prosecuted by the DOJ, by Biden's DOJ. So they're losing in every poll. They're losing in almost every demographic. Numbers came out today that are really very mind-boggling if you happen to be Joe Biden. And I think they feel this is the way they're going to try and win. And that's not the way it goes. That'll be bedlam in the country. It's a very bad thing. It's a very bad precedent. As we said, it's the opening of a Pandora's box, and that's a very sad thing that's happened with this whole situation. When they talk about threat to democracy, that's your real threat to democracy. And I feel that as a president, you have to have immunity. Very simple. And if you don't, as an example, if this case were lost on immunity, and I did nothing wrong, absolutely nothing wrong. I'm working for the country, and I worked on very hard on. Now it turns out.
Get online in.
Totally compromised by that case. It's a shame. Very good people. People did nothing wrong. They did nothing different than what Democrats have been doing for years and years and years, whether it's slates or anything else that you're talking about. But they were very hurt, and it turns out that she profited tremendously on that case. It's illegal. What she did is illegal. So we'll let the state handle that. But what a sad situation it is. I want to thank everybody for the fairness. We've been covered very fairly. Most people agree that we're entitled as a president to immunity. If you didn't have immunity, as an example, Joe Biden with the prosecutor, we're not going to give you $1 billion unless you get rid of the prosecutor that's after the company or his son or whoever it is they're after. But he wanted that prosecutor gone, and he's on tape saying it. Or you could say the horrible job he's done at the border where our country is being destroyed, or the horrible situation that took place, the lowest.
Ladies and gentlemen, also, these are some legal scholars, including Professor Dershowitz and Greg Jarrett, talking about, and this gentleman, Jordan Sekulow, great lawyers, talking about an immunity victory upcoming.
On to immunity. We've done those cases. We did those cases when the president was in office, and you remember Adam Schiff was obsessed with getting his tax returns. It's all going to come down to that question presented. And I said, Jack Smith, that may have been his biggest problem with this whole issue, is the question presented that was written by the court, Sean, which says, let's look at actual official acts of the president and whether or not official acts of the president are those acts then immune from prosecution. And I could see how this case gets a decision at the Supreme Court, Sean, and then has to be sent down all the way back to a district court to decide official versus unofficial acts. And again, this not affecting President Trump in his reelection efforts.
Professor?
Because the way the indictment is written, the way the special counsel has written the indictment, is that they've said everything he did was criminal. But that's not the speech, and speaking to allies, political allies in Georgia or throughout the country. That's not a criminal act. He's allowed to do this as a president. Okay? And so, again, he'll get partial immunity, which will be an enormous victory.
So Dershowitz, on the issue of immunity, all of us agreed that the court had an obligation to take that case up, but I know did take that issue.
Well, as you know, I predicted the outcome of this case exactly, how the court would decide 9-0 using the fifth section of the 14th Amendment. On the issue of immunity, I'm going to make a prediction here, too. I think both sides argue too broadly. I think Trump was wrong to have his lawyers say that if a president orders the SEALs to kill his opponent, he can be immunized unless he gets impeached first. That went too far. The answer should have been, of course not. Now let me explain. But I also think the lower court went way too far by having no immunity whatsoever and saying that whatever a president may have had immunity while in office, he loses that once he leaves office. I hope and I suspect that the court granted cert in this case in order to come out with a nuanced decision that focuses on precisely what are presidential acts. And if they're within the scope of presidential acts, then they have to go beyond the presidency itself. Let me give you an example. President Eisenhower in 1954 sends troops down to implement Brown versus Board of Education. One of the children or one of the police officers is killed. And the new president coming in, a Democrat, years later, wants to indict Eisenhower for having done that, even though it was in his presidential authority. I think we would all agree that there has to be some immunity, and we would all agree that he can't have total immunity for everything he did as a politician or as an individual. So I think the Supreme Court, hopefully, will come out with a nuanced decision that will give guidance to the lower courts as to when immunity is applicable, when it's not applicable. We can bring the country together on
Professor Dershowitz is brilliant, absolutely brilliant, and he's been right on pretty much everything pertaining to the Trump cases. The only thing that he's saying right now is that a nuanced decision, which would give Trump an enormous victory, would bring the country together. Democrats, media, late night, Hollywood, Saturday Night Live, famous actors who, can't name anything they dislike about Trump's policies, but they know he's really bad. They don't want the country to be unified. They want a political victory for their Democrats. Well, I'll get into it, but they want a political victory.
This issue as well, instead of simply having extreme views on both sides.
You know, I actually concur with what you just said, and I think, Greg, what Professor Dershowitz is saying.
Yes.
Judgment of the court, I think, would probably be more appropriate in this case, and maybe even the better argument for the court. Your take?
Well, I think the Supreme Court looked at the circuit court decision and said, hey, you went way too far. You're dismissing any notion of immunity, even if a president acts consistent with his duties. That is absurd logically. And it's inconsistent, by the way, and this is the important part, with the Supreme Court precedent 4 decades ago that a president does have absolute immunity from civil lawsuits as long as his actions fall within the outer perimeter of his official acts. Well, Sean, the exact same reasoning applies to criminal prosecutions. If it's otherwise, my goodness, the chilling effect on presidential decision-making.
Nixon V Fitzgerald, look it up. Nixon V Fitzgerald. Supreme Court decision, presidents are immune from civil cases. So from civil liability, civil cases, they're immune. That's Supreme Court precedent. Again, the Supreme Court is focused on history, precedent. They're not going to alter the Constitution to appease the sensibilities of angry, despotic, authoritarian, tyrannical, morally superior, highly educated, wonderful, good people who happen to be, in many cases, liberal Democrats. They're such wonderful people. They, their God, because many are atheists, which is fine. I love Christopher Hitchens. He's fantastic. I love him. But the God of many liberal Democrats is CNN, MSNBC, the New York Times, Washington Post, consensus, fabricated consensus where any dissent is completely ignored, where anyone who says, hey, maybe I'm an expert too, and maybe you've committed blasphemy and heresy, you should be excommunicated. And so groupthink is very important to the wonderful, morally superior, highly educated liberal Democrats. That's why they disown friends and family. Okay, not all of them, but a lot of them. Okay, a lot, not all, but a lot of wonderful, morally superior, highly educated liberal Democrats, not all, but some, or a good many, a great many, disown friends and family, ruin Thanksgiving, ruin holiday parties and get-togethers because they go on maniacal tirades against Trump as if that's going to help the country. Your dumb tirade at Thanksgiving dinner is not going to help anyone, and it's going to ruin the dinner.
Would trigger paralysis instead of a chief executive. So America
Greg,
would be ruled by a committee of lawyers. They'd be afraid to do anything out of fear of future prosecution.
Greg, let me ask you this. Would a more nuanced version versus the argument of absolute immunity maybe be, of course, you have freedom of speech, but you can't yell fire in a crowded building? Would that be, would there be an analogy there?
Yes.
And you would expect the court to do that.
And Jordan said this as well. I suspect the current justices will extend the existing immunity standard in civil actions to criminal cases and then remand the Trump case back to the trial court to decide whether Trump's acts are covered.
So all that has to happen is what Professor Dershowitz and the lawyers Sekulow and Jarrett stated. Brilliant. All three are very brilliant people. They don't have to give him a huge victory, ladies and gentlemen. I mean, they don't have to say he's completely immune from prosecution. They don't have to say that. They can say he can be prosecuted, which will then be manipulated in media as Trump can be prosecuted, but it has to go back to lower courts, and Trump will then circumvent prison time, and we won't be able to say convict, federal convict, prisoner Trump. They won't be able to say that's what they want. They don't really care about the rule of law. They care about imprisoning political opponents. Then they go on and say, Trump's going to be a tyrant. Oh my God. And it's just unbelievable. But again, Trump's going to win. He's going to have a huge victory, ladies and gentlemen. He doesn't need full immunity. He needs just partial immunity. Then they have to rewrite the entire indictment. It's unbelievable. It's S23. Hello, J-Spot. Hello, Henry S. Hello. To the members on this channel, hello. It's going to be a huge, huge, huge victory, people. Be here tomorrow. Be here tomorrow, ladies and gentlemen. That's going to be very important. And throughout the week and weekend. And November 5th. Mark November 5th on your calendar as one of the most important, beautiful, wonderful, awesome days in American history. Donald J. Trump will win. And you know what? I said he would in 2016. And I'm telling you he's going to do so now. Hit subscribe to this channel. God bless you all. Thanks, everybody. Huge victory ahead. Be here tomorrow. Huge victory. Subscribe if you're new to the channel.